is that cat?
Archer. You just gonna stare at me? Oh.
I am walrus. What the hell?
Hey, what's going on, everybody? It is Artie of Artie's Corporate Fiction. Happy Tuesday to you guys. Welcome. I am tired. It's been a long day today. A lot of work to do. Just happy to be home. And I'm already able to see that I'm getting Comcasted. Great. Off to a great start. But the Hillygus hearing happened. My understanding that this is to set up the jury selection. It's 2 hours long. I don't think I'm going to be able to last that long. To be perfectly honest, I'm going to try and get us through an hour. That's really all I can do, and then we'll finish it up tomorrow. But yeah, it's been a long day, so we're gonna take a look at this. Enjoy the cringe, enjoy the insanity. I also heard that BSBT had a hearing today, but we're not going to take a look at that yet. Might have to save that for later, for sure. But I apologize that I'm getting Comcasted. Yeah, I could tell. I could tell I'm getting Comcasted pretty bad. So we're gonna try and go as long, last as long as we can, I guess. But I appreciate you guys sticking with me, okay? Also, everybody wish Sergeant Rock, aka Sean, a happy birthday. Be sure to check out his channel. Again, it got nuked unfairly by the YouTubes and had to start it back up again. But yeah, y'all should do good. Check him out. Wish him a happy birthday. All right. Let's go. Do it.
Hillygus is involved on the outside should be a concern to the courts.
How come?
The Second Judicial District Court, stating that in joint session, the Honorable Barry Rosler presiding.
Thank you, Deputy. Good morning, everyone. Please be seated. Okay, we're on the record in state of Nevada versus Roger Hillygus and Stuart Hanty, case number CR19-1535A and B. Court recognizes the prosecutor's presence, Mr. Steggy, defense counsel, Mr. Silverberg, seated next to his client, Mr. Hanty, and Mr. Hillygus, self-represented. Let's set the table of contents for today's hearing. The court last week set this hearing today to discuss, consider, and decide.
Oh, I'm so sorry. I almost forgot to mention. Sathal, thank you for the $20 tip. He said, so glad to see the kitties enjoying the new tree. Hope the new GPU comes in soon, solving the problem. Taking one more thing out of your mind. Have a blessed week and watch what you asked for. We are watching. Keep doing what you do. Thank you, Sathal. The GPU is supposed to arrive either Thursday, Friday, or Saturday, according to Amazon. But I'll definitely let you guys know, of course. Thank you, man. I appreciate it.
The issue of whether there would be an anonymous jury in this matter. The court asked counsel to take a look at the Menendez-Cordero case from 2019. That was appealed from a decision by one of my colleagues to the Nevada Supreme Court. The court also indicated that it would make a final decision on whether cameras would be allowed during the trial today after the hearing on the anonymous jury.
Oh, the Nothing Burger? Gotcha.
Corollary to that was whether the court would allow the video of court proceedings to be pushed out by media sources on a daily basis, or rather direct that it be retained until the conclusion of the trial for considerations of things like rule of exclusion. Court also indicated that it would take up today confirming what we would do on Wednesday of this week, whether there's an anonymous jury or not. Wednesday of this week, when you come to court, the court intends to deliver copies of the jury veneer to all parties, either redacted because an anonymous jury has been ordered by the court, or unredacted for use consistent with preparation for trial. Also Wednesday of this week, exhibit marking. And so to the extent that there is some work to be done prior to actually meeting with the court clerk, the court directs counsel and self-represented party, Mr. Hillygus, to obtain a copy of the proposed exhibit matrix, fill it out to the best of their ability on what they intend to mark, and seek to admit a trial. It's also come to the court's attention that a subpoena was served on Debbie Hillygus. She has counsel who has moved to quash the subpoena. So we need to take up the issue of whether the court is going to hear that motion, and if so, when.
His wife?
I don't know if parties have had a chance to see that yet. The gist of it being that to the extent it seeks disclosures of confidences during or after the marriage to Roger Hillygus, it's protected by privilege unless Mr. Hillygus himself were to waive that. To the extent it seeks information with respect to her care of the late Susan Hillygus, argument appears to be that she does not have any relevant information that others would not be able to share. And finally, it appears to the court, the argument being it would create undue hardship to her. That's just the court's summary, having taken a quick view of it. But the court will.
Okay, so if you guys didn't miss that, I don't think he said specifically who did, but apparently Debbie Hillygus, Roger's wife, I don't know if they're still together or not, didn't seem clear, was served a subpoena. And I guess she lawyered up and she's filed a motion to quash. And the judge is saying that he's not really keen on, or he seems keen. It sounds like at first glance he's keen on granting the motion to quash.
We'll rule on that before she's called. We have to discuss as well. Well, let's back up. This supposes we're going to trial Monday, a week from today, which currently is the court's plan. Now, I'm aware Mr. Hillygus filed a series of motions.
Hey, Tones.
I would object. I didn't file a
Naturally.
motion.
Okay,
I filed objections and I filed a notice and a demand
to dismiss the case for lack of standing and lack of subject matter.
Oh my God, and here we go. We really are going to hear it. This really is going to be Darrell Brooks all over again, where we are going to hear jurisdiction being challenged at every single hearing until the end of this madness. So I should just mentally prepare myself now.
Personal jurisdiction. They're not motions. It's a notice and a demand for this court that once the facts are known, and if you take time and apply the law, and if you conscientiously review all the exhibits in the document that was submitted, you will dismiss the case because you will have no choice, because this is not a criminal case. There has not been any criminal act by me. And that document, that notice is quite explanatory. And if you do your due diligence, and if you apply the law to the document, you will have no choice but to dismiss the case.
All right, in the future, Mr. Hillygus, what I'm going to do is call on people to address issues that the court is bringing up. If you want to be heard, please wait until I address my attention to you.
I just need to correct
I understand, and I
the
would
reason. It's not a motion.
Okay, so, thank you. So with respect to that, unless the court finds merit in the positions that have been advanced late by Mr. Hillygus, the case will go forward a week from today. Now, when I say late, it's because I'm referring to two different rules of engagement. One is the recently enacted Nevada Rules of Criminal Practice that direct that any type of dispositive motion, declaration, opposition, notice that bears on whether the case goes forward needs to be filed within 15 days of the trial date. Our local rules for second judicial are even farther out, 20 days. Well, this was apparently filed last Friday, 3 days ago. Now, does the court have discretion for good cause?
Hang on. I'm gonna switch it to the main thing here. You're not gonna get, it's not gonna be the best, but you'll at least get subtitles with this.
To shorten that, it does. Does the court intend to exercise it here? I'm still thinking about that, since the court, it just came to the court's attention over the weekend. But, assuming we're going to trial Monday, a week from today, then I want to make sure that the state understands it doesn't seek to call J.B. Hillygus to the stand until there's been a decision on the motion to quash. Mr. Steggy, you tracking on that?
In strong disagreement, I am tracking on it though, right?
In disagreement that the court's going to rule?
Well,
disagreement that it has merit?
As to the merits, but of course I understand the court must rule on that and will weigh in on that. I will say I don't seek marital privilege communications in any way, and the idea of the burden on an ordinary citizen is objectionable to the state, and merely not wanting to because of.
Well, let's not get into the merits. We're just talking procedure. Procedurally, you're not to call her as a witness until the court's ruled on her motion to quash. All right?
Very well.
Good. So the court also filed. No, let me back up because there's a few moving parts here. Mr. Hillygus, late last week,
No, I have not yet.
The court filed an order with
Sorry.
respect to the request of This is Reno for the court to reconsider its prior ruling with respect to photographs it had taken and audio it may have captured. And the court did so after the hearing last week. The court issued a written order that confirmed what it stated on the record. And that order was filed, I believe, Friday, 3 days ago. A copy was to be mailed to you, and then for some reason it did not go out in the mail. It came to my attention this morning. I didn't want to send it out in the mail today. I gave it to Deputy Allman, who I instructed to give to you. Did you receive that from Deputy Allman, Mr. Hillygus?
I received an envelope, but I didn't open it up.
All right, I think that's what it is. as far as I know, it's simply the court's confirming order, allowing this is Reno to use the information it obtained at a recent hearing. So that's that. With respect to other news media requests, the directive is that once our standardized form is live on the website, to use that, it'll be forwarded to the court's attention. But until that's live, until and unless that's live, an email to the court administrator who forwards it to the department will get our immediate attention. Let's talk about things like jury voir dire. So on Monday
Voir
morning,
dire.
we'll talk about what time we're gonna have the jury brought up. But on Monday morning, the people that have been summoned for service will be brought into court. Say 9 o'clock, 9:30, whatever time we get going. At that time, the court makes introductory comments about service, about how we proceed in Department 8, about the role of the judge and the role of the jury. The charges that have been brought against Mr. Hillygus and Mr. Hanty by law are to be read to the prospective jurors by the court clerk. The court clerk then, then the jury veneer is sworn to truthfully answer questions put to them about their ability to serve fairly and impartially. The court then proceeds with voir diring this jury, asking questions that seek the truth as to their knowledge about the case, if any, their feelings about law enforcement, strongly or not strongly, whether they have been subject to a crime, accused of a crime, victim of a crime, things like that.
Mm-hmm.
Whether they know any prospective witnesses in this case.
Mm-hmm.
Let me stop there. When you're here Wednesday, make sure you let the court clerk know who the potential fact witnesses will be, or any expert witnesses will be in this case, so that we can put them on a list and show them to the potential jury to see if they know any of those people, and if their knowledge of them would create a conflict on their ability to serve fairly and impartially. All right, back to the types of questions the court asks. The court will ask if they have any experience with guardianships, with nursing homes, with memory care facilities. The court will ask them if they've ever been served on a jury before. The court will find out if it's been a civil jury or a criminal justice jury. The court will ask if they've ever worked in law enforcement or have somebody close to them. The court will ask if they've ever worked for a fire department or been a firefighter or have somebody close to them who's done so. And the court will ask what I consider to be very comprehensive questions of this panel of potential jurors to elicit any answers that would go toward potential bias, ability to serve, whether they have any extreme inconvenience, unjust, undue hardship that would prevent them from serving. Now, when the court is done, and that process may involve the court excusing people for cause, when the court is done, Mr. Stagey goes next. He can stand right here in the well, use the podium, and ask follow-up questions. The follow-up questions are directed to the people that have been called into the jury box or in the row in front, and he can follow up on the questions from the court. He's not to cover the same ground, but he can explore more fully some of the responses or ask questions the court overlooked that he finds bear on this potential juror's ability to serve. When he's done, Mr. Hillygus, you get to go. You're the first name.
Yay.
You can say, Judge, I'd rather have Mr. Silverberg go next, and I'll allow that, and then you can go last. But you're the A defendant here. You have the most charges being brought against you here. So I'll let you stand up You get behind the podium and ask questions, follow up on issues that bear on potential jurors' ability to serve. Make sure you have read the court's order on the scope of permissible questions.
Am I really less than 75 subs away
Asking
from
the
15,000?
jury,
I haven't been paying attention. I feel like I've been stuck at 14,800 for like
does not mean you can
months.
begin the art of persuasion with them. It is not meant to inspire them to investigate anything. It is not meant to begin to describe your view of things. It's merely to determine whether they can impartially sit and will find the facts presented to them, apply the law the court gives them. If anyone, any attorney,
The backing up truck is from the video, not me.
or self-represented defendant stray, I'll politely remind them of the scope of what they're allowed to ask. If they stray a second time, I will more strongly remind them, and if it happens a third time, the court will reserve its right to shut down their further questioning.
Uh-oh.
So Mr. Hillygus and Mr. Silverberg discussed before Monday. If Mr. Hillygus, you'd like to go second, you have the right to do so, or you'd like to wait until after Mr. Silverberg goes. When all the questioning is done, the court thanks and excuses the jurors that we don't need, and then we proceed to peremptory challenges. 24 potential jurors will be in the box. And when we have 24 that are passed for cause or over objection, the court passes them for cause. Each side can strike 4. The state can strike 4. The defense cumulatively can strike 4. So alternating. 2 by Mr. Hillygus, 2 by Mr. Hanty's side to lead to get to 4. You can certainly collaborate, but you don't have to. Once each side uses 4, we've now gone from 24 down, take 8 away, we're down to 16. Then each side can strike 1 alternate. Takes us from 16 to 14. 12 jurors and 2 alternates that will hear this case. The 2 alternates are do not know they are alternates. We know that they're alternates, but they don't. And that's the way the case proceeds. They are not to be made aware that they are alternate jurors.
That actually makes sense, because I imagine if somebody were to say, hey, by the way, you're an alternate, I feel like even if they tried not to, they may subconsciously like not care to listen as much on the trial if they knew that they were alternates.
When jury selection is over, the state has the opportunity to make an opening statement as to its view of what the evidence will show, followed by Mr. Hillygus. Again, he has the right to go second if he chooses, but after collaboration with Mr. Silverberg, if he'd like to go third, he can. And then the final defendant or counsel goes. After opening statements are done, the state will call its first witness. Examination will occur either from counsel table or from the podium, which the court allows to be moved, again, here in the middle of the well. Nobody is to approach to get more than 10 feet in front of the jury box, and nobody is to approach a witness or the court clerk or the court bench without asking permission. I've already directed that the state make sure that the defense has the opportunity to use the overhead projectors. And if there's any issue with the audio or video files, if there are any to be played here, that everyone has equal access. Speaking objections are not allowed by the court. I mean, you have to speak, but you can't make long statements about your view of things. Object, relevance, object, hearsay, object, redundant, object, need to approach the bench. There are times, Mr. Hillygus, when you or counsel will say, Judge, I'd like to bring something to your attention outside the presence of the jury, and you can ask for permission to walk right up here. typically counsel and the attorneys will say, Judge, may we approach? And if I grant that, then you come right up here, you stand right up.
Honest to God, I honestly feel like the judge is wasting his breath on Hillygus. He seems pretty clear that he's gonna pull this no jurisdiction thing for the entirety of it, and he's not even gonna bother. Like, I don't even know why the judge is even bothering with this procedural stuff, because we know what's gonna happen.
I put on a little white noise, sounds like this. So the jury can't listen to what we're saying. I mute my microphone, and then quietly, but so I can make sure I hear you. You tell me what's going on, and I'll make a ruling. If it's very important, if it's something that needs further discussion, then I'll send the jury into the deliberation room. And
Probably not, David, if I'm being honest.
That's rare, but that does happen.
I imagine not everybody paid attention to the Brooks trial.
In a moment, we're going to talk about anonymous jury. We're going to mark exhibits Wednesday. I'm still processing in the court's mind what was filed by Mr. Hillygus just recently, taking into account both its substance and also the fact that it's late.
Yeah, probably.
I've already brought up the fact that Debbie Hillygus is not to testify until the court has ruled on a recently filed motion to quash subpoena. I reminded everyone to read the order that was filed the other day on permissible jury voir dire. I've explained to Mr. Hillygus that inadvertently a copy of the order regarding this is Reno did not go out in the mail to him, so we've had one hand delivered to him. We've talked about marking exhibits. We've talked about identifying potential witnesses. I do note that Mr. Hanty, through counsel, did identify a list of potential witnesses. So we have that. The state should do the same. Mr. Hillygus should do the same. After you look at the list from those two fellows to see if there's somebody that they've overlooked. And again, those witnesses, those potential witnesses will be put on the screen or handed out to the veneer or read so they can determine if they know any of them. The recent order the court entered last week directed the sheriff to have somebody here today to speak about issues that might bear on the anonymous jury and or cameras in trial. And also, the court order last week directed the sheriff to use best efforts to make sure that Mr. Hillygus is appropriately dressed for trial.
Oh, God. I guess they're denying him
Jury
access to a
instructions should
tailored
be
suit.
filed by the state no later than Wednesday of this week, rereading our local rules. Although custom and practice is for the defense to submit theirs either simultaneously or about the same time, according to our local rules, they can actually serve them as late as the Friday before the Monday trial. They can even serve them in camera, although the court normally directs that they be disclosed to the state because we have to settle them at some point. Mr. Hillygus, I would encourage you during a break here today to talk to Mr. Silverberg about jury instructions, because even though we don't have to finalize those today, we don't finalize them this week, we don't finalize them until the end of the evidence. They're a work in progress along the route. We take breaks during trial and we go through them, or after testimony. We work, we roll up our sleeves and we go over jury instructions. So before I direct the argument on the issue of anonymous jury and then possibly evidence, Mr. Steggy, based on what the preliminary...
Hey.
The court...
Nathaniel, thank you for the 10 gifted memberships, man. Thank you so much. I appreciate it.
And there was much rejoicing.
Just made anything to add or any questions, then I'll ask Mr. Silverberg, then I'll ask Mr. Hillygus. Mr. Steggy.
Thank you.
Clarification on jury.
New members, check out them emotes.
By the passing of the statewide district court rules, they eliminated local rules, so that practice.
Well, superseded.
Superseded, right? And so that practice sort of the
I encourage emote spamming until I don't.
is eliminated by those rules. So I would just ask the court to state a time for both parties to exchange.
Well, custom and practice, what are other departments doing?
Well, that rule went away. That rule allowed for ambush. They don't allow for ambush anymore, so now they're requiring that they both be provided either on Wednesday or Friday.
Okay.
before trial.
Mr. Silverberg, strong feelings on that either way.
Preference would be Friday.
I'm okay with that.
All right, so Mr. Hillygus, summarizing this, Mr. Steggy reminded the court that the recently enacted Nevada rules of criminal practice supersede the local rules. It's the local rules that said the defense counsel or the defendant can have their jury instructions in camera no later than the Friday before trial.
Okay.
But now they all have to be delivered either simultaneously or close to it. So if you have proposed jury instructions that you want to give, you want the court to give, they need to be delivered to the court or otherwise made available by the end of this week. Do you understand that?
I would enter an objection at this time. I think I've explained to you prior that there was an order that you ordered the prosecution to provide me written rules, criminal procedure, which have not been provided to me.
Hey, Wazoo.
So I would object that he is in violation of your order, that sanctions should be issued, and that I be provided with the rules that you ordered to be provided to me in a paper copy so that I could look at them while I'm locked down 23 hours a day. Violation of my due process rights for him to violate a court order and to not be sanctioned, and for me not to be provided the rules that I need to review.
He's on lockdown for 23. No, there ain't no way that he's in solitary. I doubt that. I highly doubt that.
Mr. Steggy, would you like to respond to that?
Yeah, the court's amended rule eliminated that requirement because it was presented that you will have access by computer to a database which contains such rules, a law library, if you will.
I would object to what Mr. Steggy offers. It was a court order that he provided me with the printout. It's very clear that that was to be provided, and it was not.
Are you telling the court that you do not?
Well, Hillygus can make a claim that there are due process violations in the midst of a trial. I mean, that's not unheard of. Hillygus is claiming that a previous order of the judge was that the prosecution was supposed to provide him with a written hard copies, essentially a hard copy of the local rules, or was it the state rules? The order was say he was supposed to be provided with a written copy of that. The prosecutor says, like, well, he has access to it electronically through the law library or something like that. I think that's what he said. But Hillygus is saying that the order specifically said that he was supposed to be given a handwritten copy, or not handwritten, but a physical copy of the local rules by the prosecutor, and he says that he hasn't been provided that.
Have a copy or access to the Nevada Rules of Criminal Practice.
I'm telling you, I do not have a copy as ordered by you, a paper copy that was ordered, and I don't know if I have any other access to that. What I can tell you is the computer, the laptop is not working.
Okay, so now the judge is saying, correcting him, or the judge is trying to correct him, saying, well, no, the order said have a copy or access to the rules. Access would be meaning the electronic access to the law library. But now Hillygus is saying that the computer that he's been provided or the computer that he has access to does not work. I think that's what he's about to say.
And the password is not functional. I put in a request to the IT person to find out how I could get that. I was denied to get the IT person to fix the password, so I haven't had access to the computer. So that's another violation, because I'm being locked down 23 hours a day. I'm not being provided due process. I'm not being able to do the research that you ordered me to do. The computer and the IT people, the password would not work. I tried to get it fixed. They're denying me to give me the name of the person to provide me the information that I need to get onto the computer. I'm not being given time to use that computer. It's only 3 hours in the morning during tier time, the way the order was written. I'm not getting tier time in the afternoon, so if I don't have access in the morning, or if I don't have tier time, I can't use the computer. My due process is being extremely limited in this capacity, and as we're proceeding here, I need to advise the court that I object to this hearing. I object to anything moving forward. I'm under a physician's care.
Oh, shut the hell up. Okay, so when it comes to, so he is afforded certain rights as a pro se defendant. Obviously, the court isn't. The court's not going to hold his hand necessarily, but he, as a pro se, he is entitled to have at least some. And if he's pro se and he's incarcerated during the trial, he is entitled to have some level of access to legal resources. That's what I'm looking at. Resources. So, for example, the law library, right? Or which would have the rules of a procedure, books, and so on and so forth. So he's entitled to at least some level of access to that. I'm pretty sure he does have full access to the law library itself. He's saying that whatever computer that he has access to, he's been provided, isn't working for him. And so he's having a hissy fit.
I was medically neglected and criminally neglected I was left in the sun for 2 hours. I had heat stroke, heat exhaustion. I had a medical emergency. I was rushed to the infirmary, where I'm now being housed under a doctor's care. I'm being given muscle relaxers that I'm on right now.
Bear in mind that the question the judge asked him was whether or not he understood that he is required to provide a copy of his jury instructions by the end of the week. And now he's talking about his supposed medical issues.
Having side effects. I'm on medication that I cannot properly understand everything that's happening. I'm having dizziness right now. They have been informed that there's a civil rights complaint, because this is the second time that I've had criminal.
Yeah, thank you for the 99-cent super sticker.
And assaulted in this facility. Now there is a doctor's approval and a scheduled appointment for me to go to the hospital for therapy and for neurologic issues which are occurring, which are seizures, which are vertigo, and I'm to have therapy for that. And I'm on medication, muscle relaxers, kept up for seizures. And this has just happened, and they're trying to cover this up. And this has been now provided to the commissioners, to the state lawmakers, to the Supreme Court and others, because this is criminal negligence, medical neglect, and it's possible homicide, because I was left for 2 hours in the sun with no way to get out of the sun. They did a count where they went around.
Thank you for the 20 months, Manny. I appreciate it.
That I was in my cell when I was outside in the sun, dying of heat stroke.
Oh my God, now he's getting angry.
And this only happened 6 days ago, and I cannot proceed, and you need to understand that this is happening to me.
Okay, hold on. Two things. First thing, Kobe, please, between you and my JA, print out a copy of the Nevada rules of criminal practice and bring them back into the court, all right? Second, with respect to your medical status, I want to make sure that you are well enough to understand what we're doing in court today, that you'll be well enough to understand what we're doing in court on Wednesday, and you'll be well enough to proceed to trial. Now, are you telling me, Judge, based on my condition, medicine I'm taking, how I feel, that you haven't understood what we're doing so far today?
I'm telling you that I'm in solitary confinement, that I'm being isolated in the infirmary, that I'm under a doctor's care, that I'm under prescription medication, and I'm under a scheduled appointment for neurologic conditions at the hospital.
I'm not a doctor, but
Well, one of the options available to the court is,
I feel like if he had heat, I feel like if he had actually had heat stroke, he probably, if it was 6 days ago, I don't know. I've never experienced heat stroke, and again, I'm not a doctor. I mean, would he be like this lucid and good to go 6 days after actually suffering heat stroke? I don't know.
appoint the Washington County Public Defender to represent you for the limited purpose of advancing your position with respect to your medical condition and its impact on this matter moving forward. Because right now, you don't have an attorney to move these arguments forward or explain them to the court with documentation and testimony sufficient for the court to make any definitive rulings on how this affects your ability to understand the charge and defend yourself. Right now,
They don't last long if you receive treatment. Okay.
But
Again, if he actually is in solitary, I have to wonder what the hell did he do to earn that?
I ordered from the other day that, absent documentation or other sufficient evidence from the court, that in front of a jury or during the jury or dire process, you're not to appear in a wheelchair unless I have a good reason to allow it, a medically indicated reason, some type of documentation or some type of testimony. But let me just think on what you said for a minute. Mr. Silverberg, do you have any comments on what you just heard with respect to how it impacts your client and moving forward in this case? And I'll ask the state their view as well.
Well, I certainly don't represent Mr. Hillygus, but it concerns me when somebody comes before the court and they're unable to prepare for him for a number of reasons. His conditions of his confinement, and as well as, sounds like some serious medical conditions. Now, I believe there's a nurse here from the jail, but I'm not sure. I thought I saw a nurse, and maybe that's somebody that could enlighten the court. Obviously, Mr. Hillygus should know about his privacy rights.
Not there yet.
Maybe that's something the court and the council would want to inquire to see. Of course, it affects Mr. Hanty if Mr. Hillygus is not able to proceed in his defense. I think it is important for Mr. Hanty that Mr. Hillygus be 100% or as close as can be, so that the entire case can be presented. So I do have a concern about that. I personally feel prepared on behalf of Mr. Hanty, but a lot of that depends on Mr. Hillygus and Mr. Hillygus being ready to go forward. I haven't had discussions with him. I know he's having some medical issues. I know a little bit more about it now, just like every.
Well, I mean, has been acting like is it hypochondriac or hypochondriac? Either way, he's been kind of like throwing a whole bunch of medical issues at the wall and seeing what sticks in the last several hearings.
And it sounds to me that I would imagine his head is not foremost thinking about his defense as opposed to what appears to be some pretty serious medical issues, neurological, seizure disorder, medications. So I think that's a serious issue for Mr. Hillygus.
Thank you for the 31 months, Deacon. Holy crap.
Number two, I mentioned the witness list. And,
almost 3 years.
I believe witness lists need to be provided 10 days before trial. To the extent the state has not done so, I would object and move to dismiss on that basis, as they have not complied with the rules. They did disclose some experts last week, so I think it was on their radar, but between not getting the witness list this week, or 10 days before, and over the weekend getting another dump of discovery, a few different dumps of discovery that'll take quite a while to get through. It's a trial tactic that concerns me.
Okay, so Hanty's attorney is now saying that the prosecution has not been providing discovery in a timely manner, and also has not been providing a witness list in a timely manner in accordance with the court's order. So Silverberg, the attorney for Hanty, is saying, hey, prosecution's playing a bit of games. We're not getting these things in a timely manner or with from within the court's directive. And if the prosecution's going to continue to waiting, we're going to entertain a motion to dismiss on that basis. Because rightfully so, the defense attorney is going to say, hey, if we're not getting a witness list until the tail end, or we're going to get it late before the trial, we're not going to have enough time to effectively mount a defense or effectively prepare ourselves. So that's Hanty's counsel's argument just now.
This trial, to use the state's word, it's ambush. And that's what it is. When we're a week before trial and we're getting discovery dumped on us, things that I'm reasonably sure the state had in its possession well before. But
Yeah.
We're just getting it now.
He's arguing that they're only just now getting a dumps of discovery a week before trial when they should have received that, long before.
And it concerns me that we still don't have a witness list. Now, I know the universe of witnesses that are out there. That's quite unfair to the defense to wait until now Wednesday. Maybe we'll get the state's list of witnesses. I would get concerned about that and how it affects my ability to adequately represent the state.
Mr. Steggy, would you like to be heard on any issue we've just covered? And do me a favor, slide the microphone in front of you if you're going to be seated. If you're going to stand, keep it near you.
Yes.
Let's talk about Mr. Hillygus' health concerns that he's raised. And what impact do you believe the court should view it with respect to these matters?
Minimal impact, almost no impact. I would ask the court to reflect on Mr. Hillygus' long history in this case and in the guardianship cases of delay. Even in this case, he was ordered to appear and went on the run for a number of months. There are members of the sheriff's staff here, I think, who can enlighten on the question of the medical questions, and most importantly for the state, really planned by the defendant to seek to delay this matter as it approaches trial. I think we can all be enlightened by testimony from those staff.
Wait, you can think of the $5. I'm not gonna lie, these mics are picking up everything.
Switching to Mr. Silverberg's complaints, 174, 234.
$5 a month.
Thank you, Deacon. So this is the like about discovery most times because they're not receiving stuff that doesn't exist. Prosecution provide. This isn't a the person making the argument, Tones, is not a soft sit. It's actually defense counsel, like somebody who knows what they're doing. And he's saying, hey, we are only just now getting dumps of discovery a week before trial that the prosecutor should have had access to already and should have provided it to us long before to give us more time to prepare. And his second argument on that is that we're only just now getting a witness list, again, less than a week before trial, which again doesn't give defense counsel a whole lot of time to prepare in terms of what questions that they're going to ask or something like that. So I'm honestly on the if what defense counsel is saying is true, I can't blame him for raising the issue and saying that he might entertain a motion to dismiss because the state has not given defense counsel enough time to prepare. Well, the trial is supposed to start on Monday. My understanding is that jury selection is supposed to start on Monday. So
requires 5 days. It's 5 days before trial, so that rule's misquoted. I plan to file that. It's in process as.
You're talking about the witness list.
The witness list. I have to learn more about this discovery issue. Mr. Silverberg and I were in discussions last week about some other matters, so I would need to speak with him further about that. There was some pinpointing of things that he was interested in that we were able to work through last week. So,
and that, just to say, I appreciate that from the state, because that issue was resolved. The matters that were with anything that we discussed before, I believe they were.
So this is new stuff?
Well, it's new to us. I don't think it's new to the state. I think some of it was Mr. Hillygus's recorded statements from Los Angeles to here. So I'm sure that's something that's been in the property of the state for some time now, but I think it just.
Okay, so that's how. So, defense counsel is saying well, one of the things that was dumped on us was apparently the audio recordings of Hillygus' statements from Los Angeles. If you guys don't know, Hillygus and Hanty are alleged to have kidnapped Hillygus' mother and taken her to California, aka Los Angeles. They were picked up by LAPD, I think, or the county sheriff's office. I can't remember which one. And apparently, I guess they recorded statements, and defense counsel saying, we are only just got these statements like this week. And Hanty and them, they were arrested like what, December of 2021? So, we feel like he's saying that the state has likely had access to these recorded statements for a very long time, and only just now, a week before trial, gave us these audio recordings for us to look over. That's what the defense counsel is raising, the issues that he's raising here.
Scott, I think it was just disclosed over the weekend. 9 hours of a drive and the testimony and the statements, I'm guessing. So, it just continues to put us in a very tough position, and it's frustrating.
I said that wrong. The issue here is Mr. Hanty has been through 4 or 5 lawyers here, including representing himself. His defense has been aware and has had those materials in question for quite some time. I'm not able to today pinpoint the defense's possession of any particular piece, but I know that particular piece in review has been received by both Hanty and Hillygus side since the inception. And will you ask Mr. Hanty to stop speaking over counsel when
I'm going to ask everybody to just keep their thoughts to themselves till the court directs a question to them.
So from the inception, from when Mr. Houston was on the case, when Mr. Gilbert was on the case, Mr. Pitaro was on the case, Mr. Hanty was on the case.
So, in case you guys didn't know, Hanty has gone through several attorneys throughout this entire endeavor. And what the state is saying, the state is arguing, no, we provide this particular piece of evidence that he's complaining about. We did provide it to either Hanty when he or any one of his previous attorneys. So so he's arguing we did provide it to him. The fact that his current attorney doesn't have access to it, his current attorney needs to talk to Hanty about it. I guess that's what he's trying to argue here, that the ball is on Hanty's court to provide his latest counsel with everything that he's been provided up to this point. At least it's what I think it sounds like what the state is arguing here.
All previously been provided in conformance with Chapter 174.
All right, I understand your position. Let me think more about how to handle the concerns Mr. Hillygus has raised about his medical status.
There is one other issue that you need to also realize is that I've had an ADA advocate that has tried to represent me here and has been denied because the court is supposed to, under federal law, have what's called an ADA coordinator, not the clerk. A coordinator is completely separate from the clerk. And the ADA coordinator is to coordinate with people that have ADA issues. And I've had an ADA advocate in Missouri, and I've had an ADA advocate wanting to represent me here that's been denied. So that's also another reason that this case should be postponed until I can have an ADA advocate and an ADA representative. Americans with Disabilities Act, ADA. It's federal.
Oh, so now he cares about federal law.
They put requests into the
Well,
court.
let me do this. Let me give some more thought here while we're handling issues.
Funny how funny how Hillygus likes to pick and choose which laws he wants to recognize.
With respect to potential anonymous jury, on how the court would approach concerns that you've raised this morning about your medical status. You seem alert today. You appear to the court to have understood what I've said. You're making arguments to the court on legal positions. So I'm not going to stop this hearing and do anything with respect to appointing someone to move forward your medical condition status issues. But I may do that, but I'm not going to do it now, because what I want to do is talk about whether we're going to have an anonymous jury or not. So let's, first I'm going to invite the state to inform the court of its position on whether it believes the court should consider that and should actually order that. Then I'll invite Mr. Silverberg, then I'll invite you as well. And again, anonymous jury, anonymous. I mean, there are people, they'll come here, they're from this community, they're residents of Washoe County, they have the right to serve as jurors. If they've been convicted of a felony, they've had their civil rights restored. They have to have enough understanding of and proficiency in the English language. They don't have, must not have any physical or mental health limitations on their ability to serve. And so they come in. Now, anonymous means that we do not see their names. Anonymous means we do not see their address where they live. Anonymous means we do not see their date of birth other than the year. Anonymous means we only know what zip code they are called from. With respect to their employment, that's a close call. The court will likely redact that, but ask them when they're called for service, if they're employed in what capacity, profession, or job, and the name of their employer.
Okay, so it sounds like. Wait, so I can't recall. Did he actually make a determination as whether or not the jury's going to be anonymous or not? That was an open question in the last hearing that we heard. The issue of whether or not the jury is to be anonymous or not, I think the reason why it's raised is because of the concerns that the state raised that Hillygus and or his allies have already tried to make contact or try to do something or another with the judge, the court, and the court staff, and so there's an open concern as to whether or not they're going to do something with jurors if they know the identity of the jurors.
Then,
thank you all for the re-ups. A membership must be 8 o'clock. Yes, it's 8 o'clock.
nobody can look them up. Nobody can surf them on the internet. Nobody can run criminal justice histories on them if they're inclined to. Nobody can have people that are interested in the outcome of this case do anything that interferes with their safety or impartiality. As I mentioned, I think last week, in making this determination, the court looks to things like if the particular charges against the defendant or defendants in the case involve organized crime.
Gotcha.
There's no allegation of that here. Next factor is whether either or both defendants participate in a group with the capacity to potentially harm a juror, either personally harm or harm them, financially, economically, public scrutiny, anything like that. Third factor, any past attempts of a defendant or defendants to interfere with judicial process or witnesses. Next factor, the potential length of any period of incarceration in the event of a guilty determination. Next is whether the publicity associated with these proceedings would enhance the possibility of jurors' names being made public if they were not anonymous, and possibly expose them to intimidation or harassment. So factor one, involvement with organized crime, it's a non-factor. It militates in favor of not imposing an anonymous jury here. The other factors are what we're here to talk about, factors 2 through 5. That being said, Mr. Steggy, do you have any preliminary thoughts before we hear from the sheriff and anybody else that would like to be heard?
My preliminary thoughts, right, I would also sort of focus the court's attention on the term anonymous jury really means some degree of redaction of biographical data from these forms. I think the court's concerns are related to sort of the barrage that anyone involved in this case gets from email, actors, mailing things. Now, it's difficult to, and juror questionnaires do contain email information. There's also evidence already in this record of groups affiliated with the defendants seeking to locate information and addresses, so forth, file liens on people.
Yeah, so that's exactly what it is. So that's exactly what the state is raising, that there's already on record incidences of people associated with Hillygus. Like I said in the chat, I think he mentioned that he's a member of the Republic of Texas. That's a fairly large group, and so it wouldn't surprise me at all that those members would be trying to not attack, but, you know, intimidate, reach out, contact members of the court, the prosecution staff. I think the Hillygus already claimed that that a 3-judge panel ruled to dismiss the case against Hillygus, which I believe they're all justices from the Republic of Texas judiciary. So the concern is that if the members of the jury have their information, such as their addresses, their home addresses, public, they're going to start getting stuff being sent to them.
Associated with the case, contacting witnesses after the fact. So those are, I think, where the court's concerns are. And so to the extent that that is a risk, and there's a real risk in, by talking about this is going to give people ideas, right? People associated or affiliated with the defendants, in particular Mr. Hillygus. So to that extent, I do support redaction of some of the information contained in the questionnaires. The email address is important. Other contact information.
Phone number. Last name,
perhaps first.
Actually, first and last name.
First and last name. Particular, you know, if someone's employment status is so particular that it would be easily identifiable through sort of a general public or public domain search, I would expect that to be on the table for redaction, really to sort of respect or protect the integrity of this process. And also, the court has addressed it in the media coverage aspect as well as in the change of venue motion. I'm aware of, in sort of my brief time here, being done in 2 cases, the one being this Missmandys case. Prior to that, we did it in the outlaw motorcycle gang killing at the...
I do have an update for Archer. I'll let you guys know at the end of the stream.
Were you the prosecutor in
No.
the murder case?
In the latter I was, in Missmandys I was not. So certainly there are no broad comparisons to those types of violent groups. However, it's this prolonged and sustained and really that there's evidence in the record that it's coordinated by the defendants. And so, I would support an anonymous jury, in this case for that reason.
Okay, Mr. Silverberg, your thoughts, please.
Thank you, Your Honor. I did have a chance to look at the case that Your Honor mentioned, the Menendez-Cordero case. Also, since we didn't have a whole lot of case law here in Nevada, I looked at the Ninth Circuit as well. It expands a little bit more, and specifically I'm looking at U.S. versus Shryock, S-H-R-Y-O-C-K. And that citation, Your Honor, is 342 F3rd 948. That's a 2003 opinion out of the Ninth Circuit. Kind of breaks down those 5 elements that Your Honor talked about. And in looking at that case and looking at the Menendez-Cordero case and related case law, it seems like, one, that it's a rather extreme remedy or extreme act for a court to take, that there's a lot of concerns about the presumption of innocence and the jury wondering, oh my God, why is this happening? And there must be some real bad actors. So the courts are concerned about the inferences that are drawn by potential members of the jury panel about the defense. And they also seem to arise in the context of very violent cases. The motorcycle case, we have the case that I just spoke about, U.S. v. Shryock, where there's RICO and lots of history of violent bad actors. And none of that is present in this case.
Okay. So if you guys can't hear that, defense counsel's raising the argument that, hey, well, the raising the issue that, look, there is always going to be a presumption of innocence, and the court in previous cases has raised the argument that by virtue of letting the jurors know that some of their information is going to be redacted, it's going to make them say, like, well, whoa, what's going on here? You know what I mean? What's this guy like that we have to be anonymous? Or like, do we need to be concerned about this defendant? He's saying that that's going to draw an unfair inference against the defendant. And the second thing that he's raising, which is what I expected, which I more expected, is that, the only times when there's been an issue of making a jury anonymous like this has usually been for fairly substantial cases like RICO, gang violence, organized crime type of thing. The type of thing that you would think and expect there to be jury tampering. You know what I mean? Some noted violent offenders. He's saying in this case, it's not any of that. He's going to probably argue that Hillygus does not have any substantive criminal record prior to this. The victim is his own mother. I don't know. Well, I don't know if he's going to raise that, but he's going to argue that Hillygus does not have a long history of violent criminality to warrant this level of protection needed. That's going to unfairly potentially prejudice the jury against the defendant.
What we have here are people that are concerned about the proceedings and don't mind going public about making those concerns felt. And they're totally allowed to do that. Your Honor, just place certain restrictions, as the court is allowed to do. And I don't think it needs to go any farther than that. I think it creates, it basically creates an appealable issue that doesn't have any business in these proceedings, because these individuals are not the type of actors that we see in the cases that do lead to anonymous juries. And I think that it's going to create more issues regarding the perception of fairness of the
Thank
proceedings.
you, Brad. I appreciate it, man.
Than it is going to prevent anything from happening to a potential juror who there's no indication to think anything like that would happen. So I don't see any necessity or any real reason to veer off the normal path. And we impanel the jury in the normal sense. If there ends up being a problem, just like anybody trying to contact a juror, that's going to lead to this trial, possibly other consequences.
Not really, Sean.
But I see that as the issue in this case. And I also want to push back a little bit on the issue of lots of publicity. That really isn't a lot of publicity.
Thank you, Cindy, for the 20 months.
People that are very interested in this case, but I don't see that it's made the local news or national news or anything like that. I think it's a very small group of people that are following it and have a very legitimate, serious interest in it.
What's
But
hey, he's talking about us.
any of those folks have shown themselves to be a danger.
Nobody's paying attention. It's only a bunch of like internet law nerds who are paying attention to this case.
Thank you. Mr. Hillygus, do you have a position you'd like to share in the court?
An anonymous jury would be extremely prejudicial to me
How
and
so?
to my defense.
How so?
That this is mainly a federal racketeering, organized crime issue. That this case, the facts and the truth are being suppressed. Mr. Stagey has all of the facts and evidence through emails and text messages that I sent from Missouri and from the Washoe County Jail that are being suppressed. So to have an anonymous jury.
Let me stop. That's not helping your argument that the court should not.
Uh-oh. Alex, I redacted a portion of argument where the public is directed to a website because it is not directed at the court and could encourage the type of distraction disqualifies camera access. Oh no! Hillygus was probably like telling people, hey, everybody, go to the Republic of Texas's website and you'll see all the truth that's being suppressed. I imagine that's what that's what's happening here. I imagine that's what he redacted. I have to imagine that that's what Hillygus is saying. Yeah, that I feel like that's probably what was redacted.
Have impanel an anonymous jury. That you're actually right now talking about.
I'm speculating, but that's my guess as to what was redacted of what Hillygus was saying.
The websites that people can go to look at what you believe to be facts that support your view of things.
Well, they are facts because they have been noticed and provided to the people that are in the judgment at.
Oh, yes, exactly. Am I right or am I right? He's basically saying that people need to go to the Republic of Texas's website. So that's where they have posted all of Hillygus's motions and the judgments from their fake judiciary and everything like that. That's exactly what he's trying to say. And that's exactly what was redacted. He's trying to say a juror should go to the Republic of Texas's website and get all the truth that's being suppressed.
The 3 judges or 3 justices in Texas have made a ruling and a judgment. And just like we have 9 justices with the United States Supreme Court, SCOTUS, there are 3 justices in Texas that have made a judgment.
There it is.
All of the actors have been given notice.
Sat Hale just donated 100. They said, flashbang he hashtag bring it back.
No! Thank you, Hale, for the $100 tip. Dang it, no, I'm not bringing it back, especially not tonight. Maybe sometime this week, but thank you so much for the tip, man. I appreciate it. I really do appreciate your generosity. It really helps.
And of the facts, and they've refused to refute the facts.
Let me ask you
All
this.
I'm saying is if somebody wants to see the facts, that they can go to the site and learn the facts.
Let's talk about things like how is it prejudicial to the defense for the court to not disclose these people's names, email, phone number, and address?
There's no injury that's going to happen to anybody. There's research that needs to be done to properly select proper jurors. to anonymously hide the people is prejudicial because there is no way to know who they are, who their neighbors are, who their associates are, and this is a stacking of a jury anonymously, and it's extremely prejudicial to the defense to have people that live in this community to wonder why they have to be anonymous on a case that there is no facts. The facts are all being withheld in this case because the facts are, this is not a criminal case. And my document that I filed that you're going to review and give some deference to, you will end up dismissing the case and save the taxpayers a lot of money.
Oh, well, confident are we?
Because this case has already cost the taxpayers probably millions of dollars of unnecessary money because of unclean hands and crimes that have happened by the Reno police, the LA County, where right now there's a FOIA, Freedom of Information Act, that's being redacted 99%, 220 pages. That's under appeal. So the federal court and the Department of Justice is looking into this. There are facts in Missouri that are, I've sent numerous text messages and emails, and the prosecution has provided some of those, but they've not provided all of those. And I've asked that all of those be provided to me so that I can use those as evidence. So the facts are out there. This is not a criminal case. I did not kidnap my mother.
Okay,
This jury nullification.
okay, but I want to keep the train on the track here. The track is, you believe it was
I knew he was going to bring up. He's going to try and bring up jury nullification. That's going to be an interesting one to talk about, assuming he's going to really bring it up and bring it up heavily.
would be unfairly prejudicial to you, to the defense, to have an anonymous jury. Do I have that right?
It's absolutely should not be entertained at all.
Before I make a decision, I want to hear from the sheriff. Is there somebody here from the Washington County Sheriff's Office who can give some testimony about any activities by Mr. Hillygus that in any way would bear on this issue? Is there somebody here? All right, would you?
I hate to do this, but I do gotta stop. I'm generally getting tired. Although that excited utterance, and the tip helped out, and me realizing that me calling out what Hillygus was trying to argue, I gotta stop here. But I do want to finish this up, especially. But I wanted to stop it before we started having testimony, so we can have it all in one go and all in one. So it's not interrupted. Let me put it that way. And I'm getting kind of a headache. But so to give you guys the update, do I have the name of that website? I'm sure you could, if you could probably like either Google it, or you can you can probably find it on you can probably find it easily. But I am covertly in the Republic of Texas Telegram group, so I've been kind of keeping tabs on them through that anonymously. But in terms of Archer, Jennifer, thank you for the 1337 tip. I appreciate it, Jennifer. I appreciate it, really. You're welcome. It's not a migraine, it's just your, I don't know, stress. Maybe even dehydration, headache, who knows. Archer. I finally have his appointment tomorrow. Bright and early tomorrow morning. We're heading to the usual spot in Pennsylvania, in Philly, where they both the oncology and surgery teams are going to take a look at him, see how the inside of his mouth is doing, and seeing what the next steps are. So I'll be sure to give you guys an update for that when we're done. And yeah, he's stroke. And yeah, I'll give you guys a all the updates when we're done. He's doing beyond that, he's doing fine. Though as you guys know, he really does not like taking his meds. I need to give him his antibiotics. Pretty soon. But he's doing well. He's being his usual kitty self. So. And also, if you guys aren't a member of my Discord, which you should be, I have been giving updates, and both Winston has been using the little cubby hole over here. I've seen him in the cubby hole, and Archer, I've seen him hang out on the little hammock a little bit. So, he's doing well. Anyway. But I'm more than likely going to stream tomorrow. We're going to go through the last, so we're not waiting too long. So we'll take care of the last hour of this hearing tomorrow. So look out for that. But I want to thank you guys. And now well, Winston is also using the scratching post. I don't know if you guys even heard that. He was literally just here using the scratching post. So, hey, the cat tree is getting utility out of it. All right, guys, want to thank you for watching. Hope you have the good rest of your evening. And stay cool, stay hydrated. And I'll see you guys next time, okay? Thank you all again, as always. Thank you for your support. It's always appreciated. Adios.